Good afternoon, welcome back. We are here for the continued Colorado Revised Statute 1-1-113 hearing in the matter of Anderson versus Griswold with the interveners, the Colorado Republican State Central Committee, and Donald J. Trump, case number 2023-CB32577. May I have entries of appearances starting with the petitioners?
Your Honor, Sean Grimsley with Eric Olson, Jason Murray, Martha Tierney, and Mario Nicholas for petitioners.
Great.
Good afternoon, Your Honor. I have President Trump on the Scott Kessler. Mr. Jeff Blue, Mr. Kessler.
Good afternoon, Your Honor. I'm Ben Sisney. I'm here with Nathan Mulker in person. Jane Raskin, also with the American Center for Law and Justice, is here remotely. Also here with Michael Melito, Melito Law, and Bob Kitzmiller of Podol and Podol.
Great, thank you.
Good afternoon, Your Honor. Michael Kudlarczyk from the Attorney General's Office here on behalf of Respondent Janet Griswold. With me today is Secretary of State Janet Griswold and Deputy Secretary of State Christopher Beal.
Great. Have we, among council, talked about the order? I'm assuming we're starting with the petitioners, and then what's next?
I would assume that the Secretary of State would go next because I would imagine that the interveners would probably want to respond.
Okay, does that work for you, Mr. Kessler?
That works fine, Your Honor. And then we just had one question for the time allotted. Does President Trump and the Colorado Republican Party split, or does the Colorado Republican Party get, I think, 10 minutes of additional time?
I'm not going to cut anybody off, so let's just proceed.
Okay, well then with that, we'll probably ask the Colorado Republican Party first because they asked airline transportation issues. And then we'll back from there.
Nothing for me to decide on the airline transportation issues.
We did have a jurisdictional discussion, but I'm not sure that would work. But yeah, they will.
Okay.
And Your Honor, may I reserve time for rebuttal, given that this is a closing argument?
Sure, so why don't we do it this way? Mr. Kotlerchek already asked for 10 minutes, and we'll give approximately 10 minutes to the Republican Party, and then up to an hour each for interviewer Trump and petitioners. And if you want to reserve time, that's fine.
We'll see. We'll see where I'm at the end of the opening of the closing argument.
Do you need us to keep time, or?
I can keep it.
Okay.
Good afternoon, Your Honor. I'm sure I speak for everybody here, but on behalf of petitioners, I wanted to thank the court and the court staff for all of the time and attention that you have put in on this matter, the speed and thoughtfulness with which you have issued your rulings, all while under the brightest of spotlights. We really thank you. I wish we didn't have to be here. We are here because for the first time in our nation's history, a president of the United States has engaged in insurrection against the Constitution. He spearheaded a multifaceted scheme to stay in power by any means necessary, the scheme culminating in a violent attack on the Capitol on January 6th during the constitutionally mandated counting of electoral votes. And now he wants to be president again. The Constitution does not allow that. It's easy to forget that we are governed by a document. There's real fragility to that. The document has no weapons. It commands no armies. Section 3 of the 14th Amendment is one of the few self-defense mechanisms that document has. And it stands for the unremarkable proposition that a person who takes an oath to support the Constitution and then turns around and attacks it cannot be allowed to take the oath a second time. Such a person has proven themselves untrustworthy and incapable of ensuring that we remain a country ruled by law and not by men. Through his actions and his actions alone, Donald Trump has disqualified himself from ever holding office again. I've got some slides here. I also have a board over here, Your Honor. I'm sorry I had to put it way over there. I didn't want to block anybody. This is a slide that we used in opening. I've tweaked it a little bit. These are the 4 elements that we said we would prove and that we have proven. I'm going to talk about the first 3 today. I understand the Secretary of State is going to talk about the 4th one. And over here again, we have a board, and I'll be referencing that. The first element, that President Trump took an oath as an officer of the United States to support the Constitution. There's no dispute that President Trump took an oath. There's a stipulation to that. We all know that. Now, President Trump, I expect, is going to argue that he was not, as president, an officer of the United States, or that his presidential oath was not one to support the Constitution. I'll address those incorrect arguments later. Element 2, January 6th was an insurrection against the Constitution. And there really isn't that much in the way of dispute here either. That's likely why President Trump waited until the very end of a 177-page findings of fact and conclusions of law to make the argument. And like I said, we have a board, Your Honor. Over on this board is the standard, for both insurrection against the Constitution and engaging in that insurrection. These are the standards that were put forth by our expert, Gerard Magliacca. So for insurrection against the Constitution, that is any public use of force or threat of force by a group of people to hinder or prevent the execution of the Constitution. Now, Trump's expert, Dale Hunty, offers no alternative definition. He instead argues that insurrection against the Constitution is somehow so ambiguous that this court needs to defer to Congress. Dale Hunty is wrong. He is wrong that ambiguity, even if it existed, would require this court to throw its hands up. It is the court's fundamental duty to interpret the Constitution and say what the law is. But there is no ambiguity. The historical evidence on this is clear. Now, before we get to the battle of the experts and what they said on the historical evidence, I want to look at their qualifications, because this probably says all you need to know. On the left, we have Gerard Magliocca, who was a fan of the 14th Amendment, Section 3, before it was cool to be, and then we have Delahunty on the right. On the left, we have a professor who has not only been a constitutional scholar for over 22 years, written books and law review articles, but he has 2 peer-reviewed articles on Section 3 and a book on the 14th Amendment. He has Section 3 literature that's been cited by 2 federal courts, the Congressional Research Service, and he has testified and been found to be an expert before this case in court on Section 3 of the 14th Amendment. Delahunty, by contrast, one of the first answers on cross-examination was that he was not claiming to be an expert in the history of Section 3 of the 14th Amendment. Now, the historical evidence in support of Professor Magliocca's definition is just as clear as the qualifications when you look at the balance. So Professor Magliocca points to a number of historical sources: the whiskey and fries insurrection, which would have been well known at the time of the framing, dictionary definitions of insurrection, jury and grand jury charges, and the code of war that was used by the Union Army during the Civil War. And again, on the right-hand side, what do we have? Delahunty asking this court to throw its arms up because insurrection is somehow too ambiguous. Magliocca is correct. The January 6th events easily meet the definition of insurrection against the Constitution. There was a large group of people that attacked the Capitol on January 6th. This is from Officer Danny Hodges. There were thousands, I would say. The size of the mob was the greatest weapon. And that's on the right, a photo still from the video from the camera atop the Capitol that day. Here's testimony from Officer Pingen. There were thousands of people coming towards the Capitol along Pennsylvania Avenue. So it wasn't just the folks who were at the Capitol to begin with. There were thousands coming up from the ellipse at the behest of President Trump. The mob used violence and threats of violence. This is from Officer Danny Hodges. The crowd attacked me in a variety of ways: punching, kicking, pushing, chemical irritants, beaten in the head. I was pinned and crushed with a police shield. And we know what that video was. This is from Officer Hodges' body cam outside the Capitol. And this, even worse, somebody's phone inside. And this from Officer Pingen. How long were you engaged in hand-to-hand combat? For probably 2 to 3 hours. Did you think your life was in imminent danger? Yes, I did. And it wasn't just violence against the police officers. It was the threat of violence against members of Congress and Vice President Pence. Here is testimony from Representative Swalwell. How concerned were you for your personal safety at that moment? It was escalating as we went from gas masks to a pen in my hand to a prayer from the chaplain. And it was when the chaplain read that prayer that I finally texted my wife something I did not want to text her. And we know what the mob was doing inside the Capitol. This is the mob chanting Nancy, looking for Nancy Pelosi. That is violence and the threat of violence. Finally, it's clear that the mob's goal, and what it did in fact do, was to disturb a constitutionally mandated proceeding, namely the counting of electoral votes. This is testimony from Representative Ken Buck, who was President Trump's witness. The mob meant to disturb a proceeding. Yes, the electoral vote count on the House. And the mob did in fact disturb that proceeding. Now, Delahunty suggests that one of the reasons insurrection against the Constitution is ambiguous is because against the Constitution is somehow ambiguous. There's a slippery slope here. How do we know at the end of the day what against the Constitution means? But this court doesn't have to engage in fine line drawing exercises. There is no doubt that the counting of electoral votes to ensure the peaceful transfer of power under the Constitution is interfering with, hindering, and preventing the execution of the Constitution. Now, President Trump makes a few arguments about why this is not an insurrection. First, the mob was not organized. Somehow that makes it not an insurrection. The mob was not armed with guns. And most curiously, that people at the ellipse were happy and milling around. So too at the Capitol. These are not credible arguments. First, there's no organizational requirement in that definition over there, but the mob was organized. Let's look again at some testimony. This from Officer Pingen. The equipment that people had on: helmets, goggles, body armor, paramilitary style gear and equipment. And on the right, you have photos, one from Nate Gowdy and the other a still from the body camera of Officer Hodges. Then we have video. Coordinated attack on the Capitol, working together to try and get in to the portico on the right side where all of those officers are. Fight for Trump. Hand up the flag, use it as a battering ram. And you remember when Officer Hodges was testifying about fighting with the crowd and how a person came up to him and said, you need to watch out, people are coming up from the back? Here's what Officer Hodges had to say. This indicated to me that there was pre-planning, coordination, and that they were intentionally encircling the U.S. Capitol. And then finally, the January 6th report, this was finding 367, and there were many findings like this in the report, that this was an organized attack. While the Proud Boys and other extremists were overwhelming law enforcement at the West Plaza, another group led the attack on security barriers on the East Plaza. A military-style stack of oath keepers entered through the Columbus doors as well. This was a coordinated attack. Now, as to the assertion that there were no arms, so this shouldn't be an insurrection, again, there's no requirement for there to be arms to be an insurrection. But there were arms. As we point out in our proposed findings of fact 119, the mob brought guns, knives, tasers, sharpened flagpoles, scissors, hockey sticks, pitchforks, bear spray, pepper spray, chemical irritants. They stole items from the Capitol to use as weapons. Police barricades, scaffolding, construction equipment, trash cans. They took items off of police officers, batons, and riot shields. They were armed. And third, as I said most curiously, the idea that people were happy and milling around. You know, that there may have been some Tom Bjorklunds or Steves at the event does not change the fact that a large group of people attacked the Capitol that day. The fact that Amy Kramer believed that many of the people at the Ellipse were happy and festive does not change the fact that, A, she didn't even go to the Capitol. She went back to the Willard. But even when she was at the Ellipse, she could not see out beyond the magnetometers where the people were not so happy. That is almost certainly why, what I've just gone through, in the immediate aftermath of January 6th, there was bipartisan agreement in both the House and the Senate that the January 6th attack was a violent insurrection. Indeed, President Trump's own lawyer said as much at the impeachment proceeding. Element 3, Trump engaged in the insurrection. Now, I point back to the board again, and we have on it Professor Magliocca's proposed definition of what constitutes engaging in an insurrection against the Constitution. Any overt and voluntary act in furtherance of an insurrection against the Constitution, including words of incitement, done with the intent of aiding and furthering the common unlawful purpose. Now here, the dispute between Magliocca and De La Hunty really comes down to one thing, and that's what De La Hunty says: in order to engage, you have to have actually taken up arms. That incitement is not enough. But Magliocca, again, has the better of the argument. Here we have the comparison, again, on the left, Magliocca, he's got the first and second Attorney General opinions. Now those are significant because A.G. Stanberry was the person interpreting and guiding the Union Army in the South on what the conduct would satisfy the disqualification provisions of Section 3. There were early Section 3 cases in which this was the definition of insurrection, that it did not require actually taking up arms. There were the pre-Civil War cases, and these are particularly instructive because there, treason was at issue, levying war, and in those cases, incitement was sufficient. And then there were the congressional cases, you'll remember, where the House refused to sit certain members. One of them was the man John Brown, young Brown from Kentucky, who wrote an op-ed. The other was, I think, Philip Thomas from Maryland, who gave $100 to his son, who was going off to join the Confederate Army. There is no requirement that one actually take up arms. The only thing De La Hunty has on his side is the Confiscation Acts, which were a criminal statute at the time that made it illegal to engage in or incite an insurrection. He says because incite was used there, wasn't used in Section 3, then it must not be part of Section 3. But he ignores that that's a criminal statute. Those are often far more specific than the Constitution, as Magliocca testified. Otherwise, we'd have a 100-page-long Constitution. But more than that, he provides absolutely no evidence, contrary to what you see on the left, that anybody who was drafting Section 3 believed that incitement was somehow insufficient. He's pointed to no evidence suggesting that anyone drafting Section 3 was relying on the Confiscation Acts. And he never explains why it would make sense, given the goal of Section 3 to require taking up arms. The people that the framers of Section 3 were most concerned with were the leaders of the Civil War, of the Confederacy, Jefferson Davis, people who never took up arms. That's why, even in 1872, when Congress gave blanket amnesty from Section 3 to most Confederate soldiers, it withheld that amnesty from the leaders of the Confederacy, including Jefferson Davis. There's no requirement that somebody actually take up arms. Incitement is more than sufficient. Trump's actions constitute engaging in an insurrection against the Constitution. Now, there is no question at all that he took many overt and voluntary acts that furthered the insurrection. He summoned the mob to D.C. This is a slide we used in opening, and it shows all of the tweets that he sent out between December 19th, Will Be Wild, and his Fight for Trump video, and January 6th. But he also gave them their common purpose, and this is a slide we have not shown. And believe it or not, this is not all the tweets that he sent out dealing with election fraud. But from November 4th to January 6th, he sent out all these tweets. He made numerous speeches where he claimed there was election fraud, repeated assertions of a stolen election. Now, beyond that, he focused his supporters and the mob's attention on Vice President Pence. Here's just one example of a tweet. This is from the morning of January 6th. States want to correct their votes, which they now know were based on irregularities and fraud. All Mike Pence has to do is send them back to the states, and we win. Do it, Mike. This is a time for extreme courage. And we know that after that tweet, President Trump spent 90 minutes on the ellipse inflaming his supporters, telling them that they needed to fight or they would not have a country anymore, telling them to march down to the Capitol, where he would be there with them. I'm not going to play the speech. We played the speech a bunch of times, but I'm just putting up here some of the things that were contained in that speech. You don't concede when there's theft involved. Our country has had enough. We will not take it anymore. Because if Mike does the right thing, we win the election. If this happened to the Democrats, there'd be hell all over the country going on. And we fight. We fight like hell. And if you don't fight like hell, you're not going to have a country anymore. And most chilling of all, and fraud breaks up everything, doesn't it? When you catch somebody in a fraud, you're allowed to go by very different rules. So I hope Mike has the courage to do what he has to do, and I hope he doesn't listen to the rhinos and the stupid people that he's listening to. What could that mean other than a call to lawlessness or violence? You go by very different rules. Now, you don't need to take my word that this was a call for violence or lawlessness. Professor Simi came in and testified. He was an expert and is an expert on political extremism, including how extremists communicate. In fact, this court qualified him as an expert to testify on his interpretation of January 6th, vis-a-vis his expertise in extremism and extremist communications. Here's what he had to say about the ellipse speech. It was a call to violence. Now, Trump asserts that his language was not a call to violence. He was just using strong political rhetoric. The word fight, even though he used it 20 times, was just metaphorical. He said peacefully and patriotically once, so how on earth could he possibly have been encouraging violence or lawlessness? Well, Professor Simi explained why. Trump did not conjure his rhetoric out of nowhere. He did not just happen to choose language that would resonate with his far-right extremist supporters. He knew precisely what he was saying based on a 5-year history of call and response, where he would either call for violence and then not condemn it, or there would be violence and he would actually praise it. Now, you recall that my colleague, Eric Olson, during the redirect had the flip chart, and he wrote up some of the episodes of the call and response, and there were about 5 there. There are a lot more than that, and we put that in our proposed findings of fact. But I want to go over it quickly, just so Your Honor can see. So 2015, October, he starts saying, these are protesters. First group, he's going to be kind of nice to. Second group, not so nice. Third group, I'll be a little more violent. Fourth group, get the hell out of here. November of 2015, get the hell out of here. And that's a protester who actually then got beat up, assaulted. And President Trump goes on the news, I think it was the next day, saying maybe he deserved to be roughed up. February 1st, 2016, somebody throws tomatoes, knock the crap out of him. I'll pay for your legal bills. February 22nd, 2016, punch him in the face. March 11th, 2016, in response to violence that his supporters had committed in his name. Violence sometimes is very, very appropriate. What he said, and he said, we need a little bit more of it. On August 9th, 2016, he's complaining at a rally about how Hillary Clinton will appoint judges who will take Second Amendment rights away, telling the crowd that if she does that, there's nothing that can be done. Except maybe the Second Amendment people can do something about it. And then August 15th, 2017, this is the very fine people on both sides, the press conference after the Unite the Right rally, where somebody was killed by a far right-wing extremist. I want to stop here for a minute because President Trump, I suspect, and has already, is going to say that we're cherry-picking here, that we're just looking at what he said at the press conference and we're not pointing out what he said the day before at the White House, condemning these people. But I want to show you what couldn't be a clearer example of what Professor Simi called front stage and backstage behavior. Front stage, you tell people what you know, you're supposed to say, you don't really believe it. Backstage, you're telling people what you really think. So let's look at these two statements.
We will be discussing economic issues in greater detail later this afternoon. But based on the events that took place over the weekend in Charlottesville, Virginia, I would like to provide the nation with an update on the ongoing federal response to the horrific attack and violence that was witnessed by government. I just met with FBI Director Christopher Wray and Attorney General Jeff Sessions. The Department of Justice has opened a civil rights investigation into the deadly car attack that killed one innocent American and wounded 20 others. To anyone who acted criminally in this weekend's racist violence, you will be held fully accountable. Justice will be delivered. As I said on Saturday, we condemn in the strongest possible terms this egregious display of hatred, bigotry, and violence. It has no place in America.
And here's the next thing.
I think there's blame on both sides. You look at both sides. I think there's blame on both sides, and I have no doubt about it, and you don't have any doubt about it either. I only know that. And if you wanted to talk to you would say but you also had people that were very fine people on both sides.
You have what Trump really believes clearly on the right and teleprompter Trump on the left. It's not surprising then that after the press conference, leading lights in the white supremacist movement actually publicly thanked Donald Trump for his statements. David Duke, longtime neo-Nazi Klansman Richard Spencer, Andrew Anglin, the founder of the Daily Stormer, which is some horrific media board that deals in anti-Semitic and other xenophobic tropes. So back to the call and response. He praises in October of 2018 a politician who body slammed somebody, a reporter, I think. Somebody at a rally in May of 2019 says to shoot migrants, makes a joke, says you can only get away with that in the Florida Panhandle. Michigan, some far-right extremist supporters stormed the Michigan Capitol, and I think we're squatting there. And rather than condemn them, he writes a tweet, the governor of Michigan should give a little and put out the fire. These are very good people. See them, talk to them, make a deal. Then there were the protests in Minneapolis after the George Floyd murder. And President Trump says, when the looting starts, the shooting starts. On September 29th, 2020, stand back and stand by to the Proud Boys. October 30th, there's the Trump train that surrounds the Biden-Harris bus in Texas, slowing it down, pushing it off the road, injuring people. And rather than condemn it, President Trump says, I love Texas, and jokes that they were just protecting Biden's bus because they're so nice. And then we have, as we all remember, after the election, December 1st, 2020, election official Gabriel Sterling making a public statement calling on President Trump to condemn his supporters who are threatening election workers in Georgia. He says that somebody's going to get hurt, somebody's going to get killed. President Trump, please do something. Now, did President Trump condemn them? No. Did he do nothing? No. He retweets it and doubles down on his claims of election fraud. He is, I wouldn't even call it tacitly, approving of what his supporters are doing and what prompted Gabriel Sterling to give his message. The Olymp speech fits this pattern to a T. As Professor Simi explained, Trump used so many right-wing extremist tropes that it's simply not credible for him to assert that his words were not a call for violence or lawlessness, or that Trump didn't know what he was saying, or that people in the crowd didn't know what he was saying. And if there's any doubt about what Trump was saying that day, his former campaign manager, Brad Parscale, put it to rest. This is a text exchange between Katrina Pearson, one of Trump's witnesses here, and Brad Parscale on January 6th. Parscale, a sitting president asking for a civil war. That's how people that knew Trump took what he said that day. Now, Trump's speech did not end his involvement in the insurrection. By 1:21 p.m., he knew that there was an attack on the Capitol. Rather than do anything, he chose to let that attack go unimpeded. Now, you heard from Professor Banks, who told you all of the different things that somebody as commander-in-chief could have done that day to put down the attack. Trump did none of those things. Instead, an hour later, he sent out this tweet, 2:24. Mike Pence didn't have the courage to do what should have been done to protect our country and our Constitution, giving his states a chance to certify a correct set of facts, not the fraudulent or inaccurate ones which they were asked to previously certify. USA demands the truth. Now, remarkably, nowhere in his 177-page findings of fact and conclusions of law does President Trump mention this tweet. Certainly doesn't give an innocent explanation for it, because there is none. But simply ignoring the evidence won't make it go away. The tweet had its predictable effect. It caused the crowd to surge. This is finding 150 from the January 6th report, and immediately after President Trump sent his tweet, the violence escalated, and on the right we have a time-lapse photo or video from the top of the Capitol. This is 2:24, 2:34, 10 minutes later, 2:44, 2:45, and then I think that's 2:57. Given all of this, there's no question that Trump committed overt acts in furtherance of the insurrection. Oh, these are the two tweets that he does cite in his findings of fact and conclusions of law. This is the 338 or the 238 tweet and the 313 tweet, which he says somehow absolve him of his conduct that day, because he says, stay peaceful, remain peaceful. There are a lot of problems with that argument. First, it doesn't change the 224 tweet. Second, there's nothing in either of those tweets telling his supporters to actually go home. And while he does say support law enforcement, he doesn't say support the people that he had sicked the mob on, namely the vice president or Congress. And not surprisingly, those two tweets had absolutely no effect on the mob. Finding 134 from the J6 report, neither of these tweets had any appreciable impact on the violent rioters. Given all of this, there's no question that Trump engaged in overt involuntary acts in furtherance of the insurrection. As Professor Sini testified, how confident are you in the conclusion that Donald Trump played a central role leading these events? Very confident. The only dispute that really may exist on this is whether Trump acted with the requisite intent that day. Now, the parties disagree about what the intent requirement is for engaging in insurrection and to what extent Brandenburg applies coming in from the First Amendment. We addressed those in our briefing, so I'm not going to talk about that today. I'm just going to assume, for purposes of today's argument, that President Trump's intent standard applies, that the Brandenburg incitement intent standard applies. And the reason I'm comfortable doing that is because the evidence of intent is so overwhelming here. Trump did not give his lip speech that day in a vacuum. It was the last step in a multi-pronged attempt to stay in power by any means necessary. It started back in August of 2020, when the polls didn't look like they were going his way. He starts saying the only way we're going to lose is if the election is rigged. Election night, after Fox News calls Arizona for President Biden, President Trump, rather than go out and concede gracefully, tells America that the election is being stolen. He then turns to the courts, where he files bogus lawsuit after bogus lawsuit, using lawyers like Rudy Giuliani and Sidney Powell to lead the charge. He lost 61 out of 62 lawsuits. The only one that he won in Pennsylvania had no appreciable effect on the outcome of the election. And he did it all while knowing from his top advisors, this is finding 36, that the election fraud allegations were nonsense. Now, when he summoned the mob on December 19th with his Will Be Wild tweet, he had run out of court challenges. His only hope was to go along. That's the only way the scheme works on January 6th. But he needed the mob in D.C. on January 6th in case Pence was not willing to play ball. In case, to quote Trump from the ellipse, he needed some courage. Better to have a mob and not need one than to need a mob and not have one. By late morning January 6th, when Trump stepped onto the stage to give a speech, he knew that Vice President Pence was not going to go along. This is finding 321. There was a call in the morning between Vice President Pence and President Trump where Pence told him, I'm not going along. Now, given that call, you'd think that maybe President Trump would have revised his speech to focus on the accomplishments of his administration, because at that point, the gig is up. Vice President Pence is going to do what he needs to do. Trump did just the opposite. He amped up his speech. He added stuff to it to inflame the crowd. He added stuff to it to inflame the crowd against Mike Pence. We've submitted the teleprompter version of the speech, and you can compare it to what he actually said that day. It is a remarkable difference. This is some of the stuff that President Trump added after speaking with Pence. And most chillingly again, the last one. And fraud breaks up everything, doesn't it? When you catch somebody in a fraud, you're allowed to go by very different rules. At this point, Trump's only hope of remaining in office was violence and intimidation. That was the only thing that was going to stop certification of the electoral votes that day. Making matters worse, Trump knew that many in the crowd were armed. This is finding 105. President Trump was briefed on the risk of violence that morning. And this is testimony below from Tim Hafey that came in unobjected to. We had testimony that he was told about weaponry, that he actually asked that the magnetometers be moved, and saying these people aren't here to hurt me. That he waited, aren't here to hurt me. He also knew at the time that his supporters would listen to him. This wasn't a lark. He admitted just earlier this year on CNN how his supporters listened.
So when it was clear to you that they were not being peaceful, you saw them rushing the Capitol, breaking windows, they were hitting officers with flagpoles, tasing them, beating them up. When it was clear they weren't being peaceful, why did you wait 3 hours to tell them to leave the Capitol? They listened to you like no one else. You know that.
They do. I agree with that.
So,
If there was any, again, doubt about his intent that day, you need look no further than what he did after the speech. On the left, we have things that Professor Banks say Trump could have done as commander-in-chief to deal with the riot or the attack that day. He did none of them. That was intentional. That was deliberate inaction. How do we know it was deliberate inaction? This is a tweet he sent out just the day before, January 5th, warning Antifa to stay out of Washington. Law enforcement is watching you very closely. And then he tags the Department of Defense and all of those federal law enforcement authorities. The fact that he did not mobilize those same authorities when it was his supporters attacking the Capitol makes clear that he supported them and intended for what they were doing. Intended for them to do what they were doing. Now, there was the 224 tweet. We've already talked about that. And I want to repeat again on the 224 tweet. There is no innocent explanation for that tweet. Why, when the Capitol is under attack, Congress and Vice President Pence are in that Capitol under duress, you send out that tweet? He waited another 2 hours almost before he sent anything telling his supporters to go home. And that was a statement at 4:17 p.m. Did he condemn? Oh, and by the way, it was not until it was obvious to him that the attack would actually fail that he put out this statement. He waited 3 hours to tell people to go home. And this is a finding from the January 6th report, finding 331. It was not until it was obvious that the riot would fail that he told people to go home. The fact that he waited until it was obvious that his plan would not succeed tells you everything you need to know about his intent. And when he finally did, he didn't condemn the attackers, he praised them.
I know you heard. We had an election that was stolen from us. It was a landslide election, and everyone knows it, especially the other side. But we have to go home now. We have to have peace. We have to have law and order. We have to respect our great people in law and order. We don't want anybody hurt. It's a very tough period of time. There's never been a time like this where such a thing happened, where they could take it away from all of us, from me, from you, from our country. This was a fraudulent election. But we can't play into the hands of these people. We have to have peace. So go home. We love you. You're very special. You see what happens. You see the way others are treated that are so bad and so evil. I know how you feel. But go home and go home in peace.
This fits the 5-year call and response pattern that Professor Simi talked about to a T. 2 hours almost later, he sends out a tweet, again not condemning, saying, "Go home with love and in peace. Remember this day forever." That's intent. And I forgot to add earlier that Trump also, while all of this was going on, the attack, rather than do anything to call it off or stop it, he was calling members of Congress to lobby for them to object to the certification of the election. He was taking advantage of the duress he had created by summoning that mob on the Capitol. This is intent.
I know you.
And if that all were not enough, look no further than what he was telling people while he was at the Capitol that day. This is finding 150 from the J6 report. Chief of Staff Mark Meadows told White House counsel Pat Cipollone that the president doesn't want to do anything to stop the violence. Evidence developed in the committee's investigation showed that the president, when told the crowd was chanting "Hang Mike Pence," responded that perhaps the vice president deserved to be hanged. And President Trump rebuffed pleas from Leader McCarthy to ask that his supporters leave the Capitol, stating, "Well, Kevin, I guess these people are more upset about the election than you are." The only reasonable inference from all of this is that Trump intended to incite the attack on the Capitol on January 6th as the final desperate attempt to hold on to power in violation of the Constitution. Do we really think that somebody who had engaged in that 4-month-long scheme, unlawful scheme to prevent the peaceful transfer of power, suddenly found religion that day? That he would somehow stop short of lawlessness and violence? He had already decided the Constitution was not an obstacle, telling his supporters they could go by very different rules. And even years later, Trump continues to express his disdain for the Constitution when it stands in the way of his exerting political power. This is a Truth Social post from December of 2022, where he's still complaining about the fraud. Massive fraud of this type and magnitude allows for the termination of all rules, regulations, and articles, even those found in the Constitution. This tweet is exactly why we have Section 3 of the 14th Amendment. People who have violated their oath by engaging in insurrection have shown themselves to be untrustworthy and unworthy of taking the oath again. This right here is what 4 more years of Trump will look like. Now, I want to turn briefly to Trump's remaining defenses. And I say remaining defenses because Trump re-argues a lot of the issues that Your Honor has already decided. I'm certainly not going to address those today. And I'm not going to address all these either. I'm not going to address whether the January 6th report is admissible. You've gotten a lot of briefing on that. You conditionally admitted it. The testimony during the hearing did not change the predicate requirements for admissibility. I'm also not going to talk about Trump's inaction, whether it could constitute engagement, but to say we agree that courts generally should not be second-guessing the chief executive and whether he or she uses force. But this was no normal situation. President Trump lit the fire that was the attack on the Capitol. He alone had the powers and authorities to put that attack down. He violated his duty, which Professor Banks pointed out, to protect this country's national security. But even if inaction could not constitute itself engagement, we've got many other acts on his part. It certainly bears directly on President Trump's intent that day. So I want to start with the argument that Section 3 somehow does not apply to the president because he's not an officer or because the oath is not one to support the Constitution. First, Delahunty never explains why it would make sense to exempt the most powerful and hence most dangerous of all elected officials from Section 3's reach. And that's because it doesn't make sense. And the historical evidence, again, is clear. Section 3 was meant to apply to a president. And this, again, is Professor Magliocca versus Professor Delahunty. We have the Attorney General opinions, early Section 3 cases, 19th century proclamations, congressional debates, grand jury charges, dictionary definitions. And Delahunty relies instead on a technical understanding of what President of the United States or Officer of the United States may have meant in the original Constitution, pointing almost exclusively to the Appointments Clause, which really doesn't apply because that clause talks about other officers of the United States. And I want again to look at what Attorney General Stanbury said, because this bears directly on the question. He said an officer of the United States is used in its most general sense and without any qualification. In his second opinion, the language is without limitation. The person who has held any office, civil or military, under the United States and has taken an official oath is subject to disqualification. Now the thing is, there's really no dispute about all of the historical evidence that Professor Magliocca relies on. There's no dispute that at the time of the framing of Section 3, the president was considered to be an officer. No dispute that the 39th Congress regularly referred to the president as an officer. No dispute that the courts and contemporary jury charges did the same. No dispute that Attorney General Stanbury thought so. No dispute that the common understanding of the word defend in the oath to protect, preserve, protect, and defend meant support. There's no dispute that the presidential oath itself in the Constitution requires swearing to faithfully execute the office of the President of the United States. And there's also no dispute that when Trump's not in this courtroom, but a different courtroom in New York, where it suits his interest there, he argues that the president is an officer of the United States. This is from the briefing that President Trump submitted in the New York case regarding an issue of removal. It says the president is an officer of the United States. But while this argument that elected officials, including the president, are not officers of the United States, has been advocated by these professors, and he cites Tillman and Blackman, the very ones that now Delahunty cites, to our knowledge, it has never been accepted by any court. And as to this argument about the Appointments Clause cases somehow suggesting that the president is not an officer of the United States, here's what Trump argued in a different courtroom. The Supreme Court was not deciding the meaning of officer of the United States as used in every clause in the Constitution, let alone every statute in the U.S. Code. Obviously, the president cannot appoint himself. So, other officers of the United States must be a reference to non-elected officials. This stray line in Free Enterprise Fund, the recent Justice Roberts case, says nothing about the meaning of officer of the United States in other contexts. And finally, before he was a paid expert for Trump in this case, in August, Delahunty wrote an op-ed. And he says, although Section 3 does not explicitly refer to presidents or presidential candidates, comparison with other constitutional texts referring to officers supports the interpretation that it applies to the presidency too. The next defense is the First Amendment defense. And I'm not going to spend a lot of time on that. The only reason I'm addressing it at all is that President Trump seems to think that that is a get-out-of-jail-free card. And like I said, we have a lot of arguments about why the First Amendment doesn't apply in the way that Trump says it does here. The 14th Amendment is a co-equal amendment to the Constitution. If you engage in insurrection, that's sufficient. The First Amendment has nothing to say about it. There are other First Amendment exceptions that apply here. The employment exception, which, oh, by the way, is the one that allows you to require people to take oaths. The speech in furtherance of a crime exception, that would apply here. But as I said, we'll just assume that Brandenburg applies. And there are 3 requirements for Brandenburg. Speech explicitly or implicitly encourages violence or lawless action. It doesn't have to be violence, lawless action. We've already shown that, I've talked about it. Speaker intends speech will result in violence or lawless action. We've already talked about that. The only one left is that imminent use of violence or lawless action is the likely result of the speech. Of course it was. Not only is that what actually happened, but he was giving the speech as Congress was beginning to count the electors. He sent people at the speech down to the Capitol to give Congress people some courage. And finally, I want to address the argument that it's not for courts to decide disqualification. It's for Congress to decide only after an election. Now, this argument takes a number of forms that, and sorry, I turned that off because I'm going to get to that. The argument takes a number of forms that Section 3 is about holding office, not running for office, that the 20th Amendment somehow comes in and says this is for Congress alone, that Congress has the power under Section 3 to remove a disability, and if you disqualify somebody now, that disables Congress from being able to do that. These arguments are all wrong. First, it would make no sense to require waiting until millions of Americans had cast their votes and elected an unqualified candidate to say, oops, we need a do-over here. Applying the framers aren't stupid canon of construction disposes, I think, of this argument. Second, the fact that Section 3 requires a 2/3 supermajority of Congress to remove the disability is a textual commitment taking away from Congress the ability to impose the disqualification. How could it be that Congress, by a simple majority, decides whether the qualification or disqualification exists in the first place, but it has to vote by 2/3 supermajority in order to remove it? The disqualification exists at the time Section 3 was ratified without any action from Congress. It exists at the time somebody engages in an insurrection, and Congress has to remove it by a 2/3 supermajority vote. Trump's argument also ignores that in the context of presidential elections, states' powers are at their apex. States' powers to appoint electors, select the time, manner, and place of electors appointed, is left to the discretion of the states. This is from a recent case, Chaflo v. Washington. It was a faithless elector case. Article 2, Section 1's appointment powers give the states far-reaching authority over presidential electors. The court has described that clause as conveying the broadest power of determination over who becomes an elector. Given the textual commitment of choosing electors to states, states are well within their rights to protect against wasting their electoral votes by keeping a disqualified candidate on the ballot. And then, now Justice Neil Gorsuch said as much in Hassan. He said, a state's legitimate interest in protecting the integrity and practical functioning of the political process permits it to exclude from the ballot candidates who are constitutionally prohibited from assuming office. Fourth, the historical evidence is not with Trump. As I said, the disability existed at the instant Section 3 was ratified. That's why people began applying for amnesty right away. That's why courts began right away enforcing it. And Trump's argument, again, would prove too much. Courts in Colorado, California, other states have long ruled that presidential and other candidates are ineligible because of federal constitutional requirements, such as being too young, not being a natural-born citizen. And then finally, the 20th Amendment. The 20th Amendment is not about this. The 20th Amendment is about a very peculiar situation where there was no remedy for before, and that is if a disqualification came to be after the president was elected or was only discovered afterwards. That was what the 20th Amendment was about, and that's why the only court to have addressed this issue rejected the very argument that Trump makes here. Nothing in its text or history suggests that it precludes state authorities from excluding a candidate with a known ineligibility from the presidential ballot. And finally, if Congress wants to remove the disqualification, they are free to do that at any time for President Trump. Colorado is not required to put a disqualified candidate on the ballot and risk disenfranchising millions of its voters on the off chance that supermajorities of both houses of Congress might remove that disability in the future. And let's be honest, it's not going to happen. I'll reserve the remainder of my time.
Good afternoon, Your Honor. May it please the Court. Michael Kotlarczyk on behalf of Colorado Secretary of State Janet Griswold. I want to start in a similar place to where Mr. Grimsley started, which is thanking the Court on behalf of the Secretary for the Court's tremendous, and the Court staff's tremendous investment of time and resources in deciding this matter. As the Court is well aware, the Election Code requires the Secretary to certify the primary presidential candidates on January 5th, 2024. And I'm pretty confident, like everyone else in this courtroom, we fully expect that some appellate process is going to play forward from whatever this Court decides. So in light of that, the urgency with which the Court has treated this matter is deeply appreciated. Fundamentally, Your Honor, this case poses two questions. Number one, did former President Trump incite an insurrection on January 6, 2021 within the meaning of the 14th Amendment, such that he is disqualified from holding that same office again? And number two, if so, does the Colorado Election Code permit him to appear on the presidential primary ballot? As we have stated throughout these proceedings, the Secretary has presented no evidence or argument concerning the first question as to whether President Trump incited an insurrection on January 6th. The Secretary has deferred to the other parties to present their evidence on that issue and leaves that matter in the court's capable hands to resolve. Instead, as Colorado's chief election official, the Secretary in this proceeding has focused on the second question and sought to provide the court with guidance as to the meaning of the Colorado Election Code in this unprecedented situation. And it is to that matter that I'll direct my brief remarks today. In his proposed findings, former President Trump argues that neither the Secretary nor the court have the authority to keep disqualified candidates off the ballot. We disagree, and to understand why he is wrong, Your Honor, we need to start with the ballot itself. The purpose of a ballot is to elect candidates to office, as the Supreme Court held in the Timmons case that we cited in our papers. And this is true for presidential primaries as well. In the case of a presidential primary, ballots serve to allocate delegates for a party nominating convention, but in either case, ballots are what voters use to select their candidate. Having candidates who are ineligible to serve in the office they seek frustrates that purpose. As the Supreme Court stated in Anderson v. Celebrezzi at 460 U.S. 780, as a practical matter, there must be substantial regulation of elections if they are to be fair and honest, and if some sort of order, rather than chaos, is to accompany the democratic process. The voters of Colorado recognized these principles when they adopted Proposition 107, creating the statewide presidential primary in 2016. Section 1-4-1201, which was enacted in Proposition 107, states that the presidential primary process should, quote, conform to the requirements of federal law. This, of course, includes all of the requirements of the United States Constitution. And Section 1-4-1203, 2A, states that, quote, each political party that has a qualified candidate entitled to participate in the presidential primary election pursuant to this section is entitled to participate in the Colorado presidential primary election. So to conform Colorado's presidential primary process to federal constitutional requirements, if the court concludes that former President Trump is disqualified from holding the office of president under the 14th Amendment, the court should order him to be excluded from the ballot. The contrary view expressed by former President Trump would produce an unreasonable outcome and would disenfranchise Colorado's voters, both of which outcomes are disfavored by Colorado law. According to his view, neither the Secretary nor the court could exclude, for example, an 18-year-old who submits the necessary paperwork to be president, or someone who is not a native-born citizen. But such candidates could never serve as president. So no valid purpose is furthered by including them on a ballot. As then Judge Gorsuch stated in the Hassan case, Colorado has a legitimate interest in ensuring that only qualified candidates are certified to the ballot. And it's the legitimate interest that we seek resolution of in this matter, Your Honor. So from the perspective of the Election Code, and specifically Section 11113, the question is whether it would be a breach or neglect of duty or other wrongful act if the Secretary certifies a disqualified candidate to the ballot, and whether the court can enter an order directing the exclusion of such a candidate. Under 1-4-12041, the Secretary is responsible for certifying names to the presidential primary ballot, and the code clearly imposes a duty on the Secretary to exclude certain candidates from the presidential primary ballot. And I'm citing here, Your Honor, to Section 1-4-501, which is made applicable to the presidential primary process through 1203. The Secretary has to exclude any candidate from the ballot who fails to swear or affirm under oath that he or she will fully meet the qualifications of the office, if elected, a candidate who is unable to provide proof that he or she meets any of the requirements of the office related to residency, or who the Secretary herself determines is not qualified to hold the office based on residency requirements. Importantly, a presidential primary candidate who is disqualified under Section 3 of the 14th Amendment is no more entitled to appear on the ballot than one who fails to meet any affirmative qualification for the office of president. To hold otherwise would be contrary to the electorate's and the General Assembly's express intent that only qualified candidates may participate in Colorado's presidential primary, and that the Secretary of State certification of such candidates must conform to the requirements of federal law. To effectuate that intent, the Election Code creates an express cause of action under 1-4-12044 for any challenge to the listing of any candidate on the primary election ballot under Section 11113. And that's the provision, of course, that the petitioners here have invoked. When these provisions of Colorado law are read together and harmonized, as they must be, they authorize this court to act if an election official breaches or neglects a duty or commits or is about to commit another wrongful act. Now, as the Colorado Supreme Court has recognized, other wrongful act is broader than just those acts that are breaches of duty. Former President Trump is thus wrong when he says on page 37 of his proposed findings that the court only has jurisdiction under 113 if the Secretary has a mandatory duty to act in a particular way under the Election Code. Other wrongful act is broader than a mandatory duty to act in a particular way. And in light of the need for the presidential primary process to conform to federal law, and for only qualified candidates to participate in the primary, it would be a wrongful act within the meaning of 113 for the Secretary of State to certify a candidate to the ballot who is disqualified under Section 3 of the 14th Amendment. In his proposed findings, the former president also makes much of the lack of historical precedent for the Secretary to exclude a candidate from the ballot for failing to meet constitutional requirements. Your Honor, the Secretary readily concedes that this is an unprecedented situation, but the absence of evidence on this point is by no means evidence of absence. The Secretary frequently must confront unprecedented situations when administering Colorado's elections. Before the 2016 presidential election, the Secretary of State had never been confronted with rogue presidential electors in the Electoral College. But when the former Secretary was, a division of this court, decided that the provisions of the Election Code that binds the votes of such electors was valid and enforceable. Before the 2020 presidential election, election officials in Colorado and across our nation had never before confronted widespread, baseless claims of a stolen election. But when they were, those claims were heard and disposed of by numerous state and federal courts. To be sure, Your Honor, we live in unprecedented times, but the rule of law still controls. And that rule gives courts of general jurisdiction like this one, empowered by the Colorado Election Code, the full power and authority to consider and decide legal disputes like the one presented here. For these reasons, Your Honor, the Secretary of State respectfully requests that the court decide the merits of petitioner's claim under the Election Code. Thank you.
Good afternoon, Your Honor. This court's heard a lot. This court's been through a lot. So has the court staff. We also appreciate that. The petitioners and even the Secretary, with due respect, have complicated things. I would like to bring the court back to the basics. More than anything else, this is the case about the law. This is a Section 113 proceeding, intentionally and expressly limited in scope by the Colorado legislature. The only relief available is for this court to order the Secretary to comply with the election code, or substantially comply. This is also about Section 1204. We've heard some of that this afternoon. That contains a finite and enumerated list of shalls, ministerial duties with which the Secretary must comply. She has no discretion with that list. The Colorado Election Code does not contemplate, actually it does not even allow, a discretionary role for the Secretary in determining extra statutory qualifications in usurpation of the major political party's will. It includes no vesting of such authority. It gives her no budget for such a pursuit. It sets no guardrails. Her duty is the shalls. Here's some more of what the law says. According to Section 1203, 2A, and I quote, each political party that has a qualified candidate entitled to participate in the presidential primary election, I'd like to emphasize, pursuant to this section, is entitled to participate in the Colorado presidential primary election. In other words, Your Honor, qualifications are still based on what the party, the political party, determines. Section 1201 provides that a legislative intent, the intent behind the provisions of this Part 12 conform to the requirements of federal law. We just heard that. What I think was omitted, well, it was omitted. And national political party rules governing presidential primary elections. Those are in the record, Your Honor. But conforming to federal law does not give rise to an independent right, let alone a duty on the part of a state official to enforce Section 3 of the 14th Amendment. This is distinct from some of the residential requirements we heard about that apply to state candidates. In fact, the Secretary's representative, Ms. Rudy, acknowledged that the Secretary's role in the ballot qualification process has been, as a practical matter, ministerial. Lawyers know what ministerial means, as opposed to discretionary for state officials. Her responsibility under the Election Code is to either confirm that a candidate is affiliated with a major political party, according to the statute, and is a bona fide candidate, pursuant to that party's rules, or alternatively, to confirm that the candidate submitted a properly notarized candidate statement of intent. Ministerial, nothing else, just that. That's uncontroverted evidence from the Secretary's representative. It is the political party that's vested with the power to determine its bona fide candidate, not the Secretary. I run the risk of belaboring that point, Your Honor, but that's a very important point in this case. I'd like to direct the court, I won't read it all for the sake of time. Day 3, direct examination of Hillary Rudy, page 116, lines 3 through 7. This one I'd like to read. Question, what does it mean to be a bona fide candidate? Answer, I don't know what that means to the party. From our perspective, it means that the party approves that that candidate represents the party. Day 3, direct examination of Hillary Rudy, page 97, lines 17 through 21. I quote, our office looks at the information provided in the affidavit itself. If the affidavit is complete and we have no affirmative knowledge that any of the information is incorrect, then we would qualify that candidate to the ballot. Later, Ms. Rudy confirms the ballot access team does not do any investigation beyond the review of the paperwork to ensure it's accurate and complete, to review the party's paperwork to ensure that the approved box, as opposed to the disapproved box, is checked. That's day 3, page 108, lines 10 through 13. There's a few more that the court heard that I'll move past for now. The Secretary's representative conceded the role for the office is ensuring that the required paperwork is completed, not determining whether substantive affirmations of constitutional qualifications are accurate. Again, nothing in the statute gives her that authority. Such a pursuit certainly requires guardrails, standards, a budget, restraints, due process protections. It's not in the code. It's not in the code that 113 authorizes this court to order that the Secretary can substantially comply with the code. That's it. Obviously, the questions this court is grappling with today are at issue in other states around the country. It's not a secret. While of course not binding on this court, Your Honor, both Minnesota and Michigan, courts have recognized the same principles. We're submitting to you here today the limitations of election code, state election code. Groh versus Simon, this is the Minnesota Supreme Court, issued an order last week rejecting efforts to keep former President Trump off the ballot in that state. I'd like to quote, although the Secretary of State and other election officials administer the mechanics of the election, this is an internal party election to serve internal party purposes. That opinion has been filed to record as a notice of supplemental authority. That code, the election code in Minnesota, is substantially the same as the code we're dealing with here. The argument that the Secretary's oath, this is an argument we've heard, that the Secretary's oath to defend the Constitution vests her with the power to enforce, by barring candidates from ballots, to enforce Section 3 of the 14th Amendment. A court in Wayne County, Michigan, Monday night, just dismissed a similar case, explaining, and I quote, there is no support for the plaintiff's position that an oath to support the Constitution of the United States incorporates a duty to enforce a provision such as Section 3 of the 14th Amendment. I submit to the court respectfully, nothing in the election code of Colorado does either. That court also held that imposing legal duties on the state election commission, the relevant office in Michigan, that are, quote, beyond the scope of the plain language of the statute, close quote, failed to state a claim upon which relief could be granted. They were asking the court to infer something into the election code so that the state official could enforce it. This court has heard the same argument here. I just would like to emphasize, Your Honor, beyond the scope of the plain language of the statute. I recall in the Secretary's brief, the omnibus brief, the Secretary admitted that the statute does not explicitly vest her with the independent authority, I believe this is how it went, but instead they're asking the court to infer it into the code. Then, even more recently, the Michigan Court of Claims, this opinion I think was also filed, just dismissed similar cases last night. That court noted that the Michigan election code was such that, and I'd like to quote, such that the Secretary has neither the affirmative duty nor the authority to separately, back up, the affirmative duty nor the authority to separately decide whether Donald J. Trump will be placed on the Michigan presidential primary ballot on the ground that he's disqualified under Section 3. I submit to the court that that election code provision, that issue was at issue in that case, before it was dismissed, was substantially similar to the code before this court today. That court declined to read something into the statute, something very monumental, barring a candidate that a major state political party has decided to place on its primary ballot. Now, even if this court were to find a way past the limitations of Section 113, 1204, neither the Minnesota nor Michigan courts did when they faced an analogous state law framework, this court will still be faced with the issue of interpreting the 14th Amendment. As we briefed extensively, won't repeat it all here certainly, it is black letter law that constitutional provisions can be self-executing as a defense, not as a cause of action. Very different. To start, the 14th Amendment as a whole does not create a cause of action. I'd like to refer the court to the United States Supreme Court opinions cited on pages 68 and 69 of our proposed findings and conclusions. There's one I'd like to read, for example, Ownby versus Morgan, 256 U.S. 94 at 112. It cannot rightly be said that the 14th Amendment furnishes a universal and self-executing remedy. Section 5 of the 14th Amendment confers the enforcement power on Congress to determine, and I quote, whether and what legislation is needed to, close quote, enforce the 14th Amendment. That's Katzenbach versus Morgan, 384 U.S. 641 at 651. There's a series of circuit cases we've cited.
Mr. Sistine, I specifically said at the end of the last hearing that if the state party wanted to have time with the oral arguments to ask for it, the Secretary of State asked for it, the Colorado Republican Party didn't, then at the beginning of this hearing you did, and I said you could speak, and I said it would be limited to 10 minutes, which is what the Secretary of State did. You're now at 13, and it's just getting late, and I think Mr. Kessler has a lot of time, and all of this has been briefed, and so if you wouldn't just mind wrapping up, I'd really appreciate it.
Yes, Your Honor, I apologize. Thank you. Certainly. In Bush versus Gore, the United States Supreme Court held that a state court's order to determine the intent of a voter violated the Equal Protection Clause, in part because, I quote, the absence of specific standards to ensure its equal application. That absence rings loudly here. What standards will guide the Secretary's pursuit that they're asking this court to order her to do? Republican Party of Colorado respectfully urges this court to deny all the relief sought by the petitioners, dismiss their petition, and enter an order declaring that the Secretary must comply with the code as written, not as certain people wish it to be. This is the law. Thank you, Your Honor.
Thank you, appreciate it. Mr. Kessler, let's start up at 35 after, since we've already been going for almost an hour and a half. I'll just take a quick bathroom break, okay? We'll start with you at 4:35, and you'll get a full amount of time.
Thank you. If I may stay standing, Your Honor. So, Your Honor, thank you very much for the ample time here, and we certainly respect all the hard work that's gone into this. I don't think I've ever filed such a long brief in my life, 120 pages, or 170 plus pages. 177. Well, and I felt like, my gosh, we did 177, and they only did 75, but then there's a single spaced. So it's equivalent. So let me talk a little bit about the case here. What this case, after we've looked at the evidence, after we've completed this 5-day hearing, I think what this case comes down to is whether or not the court is going to file the January 6th report. This case is about the January 6th report, to be frank. And what the petitioners have done is they have taken the January 6th report and tried to get this court to accept it as evidence, to accept its conclusions, to accept its logic into this case. Basically, they took the January 6th report, they pulled a handful of witnesses from the January 6th report to testify. They pulled curated and frankly, in some instances, edited videos from the January 6th report. They had Professor Simi rely on the January 6th report. They had Professor Magliocca rely on the January 6th report in some of his application. They cited the January 6th report. They've relied on it 67 times in their findings of fact and referred to it another 4 times. And they've asked this court to endorse 96 findings. Findings, I would almost say, is a somewhat shall we say, charitable characterization. It's 96 conclusions. It's 96 opinions. It's 96 pieces of reasoning that the January 6th presented. And so what I would say is that the petitioner's case, the foundation of it is rotted. It is a rotten foundation. The January 6th report was originally used for political purposes as sort of a election issue, and that has failed. I mean, like it or not, for the authors, President Trump remains viable and in many instances considered a leading candidate for the presidency. The authors of the January 6th report attempted to use it to get criminal charges, certain criminal charges filed against President Trump. That failed. Those criminal charges, for example, incitement of an insurrection, those were never filed. And now the petitioners are trying to use the January 6th report to get it into evidence. Excuse me one moment, Your Honor. I need to turn on my timer of all things. I'll subtract a few minutes. Don't worry.
35, so it's right there.
Okay. And really, at the end of the day, it is a rotted foundation, and it is another attempt at the January 6th, using the January 6th report to limit people's ability to vote. The other technique that they've used, of course, is talking about violence. Anything that smells of violence, that smacks of violence, is all sort of in cahoots with one another. It's violence. Violence is insurrection. That's bad. And so President Trump is responsible for all of it. The third tool they use is relying on Professor Simi at length, and I'll discuss that. He studied far right-wing extremists, and the goal is to take that small group of people and apply to everyone and infer intent to President Trump, frankly, without evidence, especially when Professor Simi specifically disavowed that he addressed President Trump's intent. But they want to rely on that anyway. So I'm going to talk a bit about the January 6th report. Petitioners didn't, but I think it's pretty important, and we will talk about that, because this court has conditionally admitted it, and so, although the decision of admission has already taken place, this court should not place weight upon these findings absent evidence at this hearing to support those findings. And there's a lot of those problems where there's these sort of findings, as I put in scare quotes, without evidence to support it. I'm going to talk a little bit about the legal standards, and I will lightly revisit the jurisdictional arguments. We briefed those, obviously pretty thorough. I'll try and be brief on those, but I will say this. The petitioners are asking this court to do something that has never been done in the history of the United States. It's not been done when Horace Greeley ran for president. It's not been done when Eugene Debs ran for president. It's not been done for any presidential candidate in the history of our republic. And the evidence doesn't come close to allowing this court to do it this time as well. And with respect to this court's jurisdiction, I would note that since this case has been filed, there have been 3 directly on-point cases, one from New Hampshire, the Supreme Court, one from Minnesota, the Supreme Court, one from a court in Michigan. This is in addition to all of the other courts that have dismissed this. And those cases have directly addressed and refuted, or I should say ruled directly against, several of the petitioner's jurisdictional arguments. So I think the court should look at that reasoning and consider what perhaps I think was fairly characterized as an emerging consensus here within the judiciary across the United States. And then finally, I'd ask this court to step back. At the end of the day, there are serious questions about this court's jurisdiction. We've raised those and briefed those, okay? But I'd also submit that we're talking about whether a presidential candidate of the United States committed an insurrection, engaged on an insurrection, and we're going to try and decide this issue based on a 5-day hearing, and you've heard our concerns about the procedures of this hearing. But at the end of the day, it's a 5-day hearing with 17 and a half hours or so per side, which is basically papered over or underpinned, as one may describe it, with the January 6th report to determine constitutional rights, issues of first impression in the history of the United States with consequences. I submit that this court, as the Michigan court said, no matter how well-meaning, no matter how fair, no matter how thoughtful and well-intentioned, even-handed, fair, and learned, the court cannot in any manner or form possibly embody the represented concerns and qualities of every citizen in the nation, as, in this case, the Michigan court referred to the House of Representatives or the Senate, and also noted that judicial officers in states are not empowered. So we submit that this court should look at that with a different set of eyes than it has to date. Let's talk about the January 6th Commission. So we've cited the standards, the legal standards, for when a court should consider or admit congressional reports. And among those considerations are whether there is a hearing along the lines of an adversarial hearing, and motivational problems that a congressional committee may have. And courts have specifically highlighted the fact that for congressional commissions and committees and committee reports, there are partisan considerations. They've said election officials have a tendency to grandstand. I don't know where they got that from. A big issue is whether or not the minority joins in the majority. And of course pointed out that when there are bitter divisions arising from that, that's evidence that it's that it's more politics versus policy or truth seeking. That a report that's truly reliable on a methodological and a procedural levels are unlikely to create these bitter divisions. So that's all things that this court should look at. The January 6th committee was biased from the start, heavily biased, in fact, overwhelmingly biased. And I know this court and the petitioners have pointed out there were 2 Republicans on the committee. But that's not the standard. This is not a Republican-Democrat issue that we are looking at here today. The issue we're looking at is whether President Trump engaged in an insurrection. That's the issue. That was the issue that the January 6th committee investigated as well. The 2 Republicans on that committee, along with all of the Democrats on the committee, were unified in their belief, in their vote. Every member had voted that President Trump had incited an insurrection. Every one of them voted on that. Every one of them said that. Every one of them believed it. And Mr. Hafey, he testified that for them it was an obvious fact. An obvious fact is what he said. Every member voted on that obvious fact. Now, if you look at the petitioners will repeatedly cite that, well, it was bipartisan vote on the impeachment. Well, if you look at the impeachment vote in the House of Representatives, it was a 54 to 46% split. And the 46% they voted against President Trump incited an insurrection. And the number of people that were on the committee representing 46% of the House of Representatives, that viewpoint was 0. None. It was stacked. Lots versus 0 was the lineup. Everyone on that committee started from the proposition that it was an obvious fact that President Trump incited an insurrection. They then spent a year and a half looking at it, and lo and behold, they came up with the conclusion that he incited an insurrection. No surprise there. Let us look at the witnesses that talked about the January 6th committee. So we presented Congressman Buck. I jokingly say Congressman Buck was for us a witness out of central casting. He was a credible witness. He was not, and is not, and you heard nothing about him being a fan of President Trump. He's not a President Trump lover. So he wasn't here to cast love upon President Trump. He is on good terms with Representatives Cheney and Kinzinger. He had worked for Representative Cheney's father and knew the family and knew her. So he didn't consider himself a close friend, but he was not someone who demonized those 2 Republicans. He had announced the day before his testimony that he would not seek re-election. So he was a man liberated from political concerns. And in fact, in many ways, he testified to certain facts the same as Representative Swalwell. He wasn't trying to spin things. Other things that Representative Buck brought to the table was he's a member of Congress, obviously, but just as importantly, he's a former staffer of the Iran-Contra Commission that investigated the Iran-Contra controversies, and so he knows what a proper investigation looks like. And if you remember, I was a young adult when this happened, very young adult, but the Iran-Contra was when President Reagan was accused of selling arms to Iran so he could have money to give arms to the people fighting the Sandinistas in Nicaragua. So that was the Iran-Contra controversy. And there were claims and beliefs that President Reagan should be impeached. Very great controversy. Just as much of a hothouse controversy is what Congress faced in early 2021. And Representative Buck said, look, we had a majority and we had a minority. And witnesses were fully examined. And more importantly, the minority was able to call witnesses to whether bring in new evidence or rebut or to point out the irrelevancy or whatever those arguments may be of the majority's witnesses. And not only witnesses, but to obtain facts and documents and develop facts and obtain documents that contradicted the majority narrative. On top of that, Representative Buck was a former prosecutor for about more than 20 years. And so he knows what an investigation looks like. And he likened the January 6th as him taking witnesses and whatnot and going into court without the defense present, without the defendant and without defense counsel even present. That's how one-sided he viewed it. He also testified that Congress's goal is political. It is political. And now, look, we have this Madisonian government of checks and balances, and that's designed so that, as Madison said in Federalist Number 10, that certain factions and balances will cancel one another out. And so you even have those checks and balances built into congressional investigations. In other words, you have a majority and you have a minority, and they each bring in their evidence, and then they present their own reports. Sometimes they agree, and when they agree, the courts have said, well, we're going to give that more credence, far more credence. And we're probably not going to give any credence when they don't agree, because then, particularly when there's bitter and sharp divisions, as there have been here. So there were no checks and balances in that process. The adversarial process, how do we have checks and balances in the court procedures? Through an adversarial process. That did not exist in the January 6th report. So when you receive a conclusion that the January 6th report said this happened, that's not part of an adversarial process. In fact, the quote, judges in that instance, the people who decided that, were all very biased from the start. And of course, you have the checks and balances of the judicial versus the political process. This is a judicial process. The reason people have faith in courts, the reason we devote our lives to this, is because we have an adversarial process, and we believe that with the adversarial process is the best opportunity to determine what the truth of the matter is. What the petitioners are asking you is to import into this judicial proceeding something that was the antithesis of the adversarial process, was the antithesis of a fair and balanced approach, was the antithesis of having decision makers look at this with an open set of eyes. It was the antithesis of that. And they're asking to import that into what should not ever be a process that has those types of infirmities. Second, you have Mr. Hafey. He confirmed, frankly, very critical facts. He confirmed that there was no minority staff. He confirmed that there was no minority report. He confirmed that everyone on the committee had voted on impeachment that President Trump incited an insurrection. He admitted that the committee was very unusual and that it was basically stacked with prosecutors. He admitted that it was very unusual, the process, because the members themselves, remember the members who had already decided what had happened, who already viewed as an operative fact incitement to insurrection, that those members took a leading role and were heavily involved in the processes. So this was not an instance where professional staff was allowed to go forward. This was an instance in which they were heavily directed by the members. In fact, not only were they so heavily directed, but one of the staff members represented as an attorney, and I just don't know how this happens, but as an attorney, he represented Representative Kinzinger as his attorney, while also serving as an investigator on the committee. So his loyalty was directly to make sure that that congressman's will was taken care of. If you're an attorney, you've got that duty to your client. And yet he had two duties, which he viewed apparently as not conflicting as one duty. Mr. Hafey also admitted that the volume, the number of documents or the number of witnesses, does not equal fairness, because he pointed out how, he's done grand jury investigations with lots of documents, but they'll still have to be subject to the adversarial process, which of course they weren't in the January 6th. And he himself readily admitted he was a Democrat. He's been fired by a Republican, and that he's viewed himself as a partisan and was a political appointee. I walked through during that cross-examination, not only the impeachment vote, but the fact that the committee members had made up their minds. And I certainly respect Mr. Hafey for working to defend his the process there. But when I confronted him with those comments, the public comments, he sort of said a few things. One, he said, well, it was an operative fact that, or an obvious fact was his testimony, that every one of the committee members started out with. Second, he said, well, it was really sort of a hypothesis, and they really had an open-minded. I just don't think that's credible or believable. And then thirdly, he said, they had made some preliminary determinations, hypotheses based on what they saw, but again, wanted us to plug into and test that against the evidence we were finding. And then he says, so I don't believe Mr. Aguilar, he was referring to Mr. Aguilar, one of the committee members, or any of the others, made any conclusion other than that preliminary one informing that impeachment veto. In other words, he viewed the vote that they made as a preliminary conclusion. Well, I disagree with that as well, and here's why. I would submit to the court that congressmen and congresswomen spend a lot of effort, blood, sweat, maybe not blood, but sweat and tears, getting into Congress. It's a big deal. It's hard work. You sacrifice a lot. And then they get to Congress, and their main job is to vote on things. And this was a seminal vote everyone is looking at. This isn't some preliminary. This is one of the most important votes they took in Congress during that time. In fact, Ms. Cheney and Mr. Kinzinger, are no longer in Congress primarily because of these votes they took, I would submit. So this wasn't some light preliminary vote that they took. This was something they were committed to, that they were representing their constituents on, and that they believed in, and that's why they took that vote. They took the vote, they controlled the investigation, and they came up with a conclusion that matches exactly how they voted. And then, of course, you have Congressman Nell's affidavit. He basically testified to, I think, some procedural, relatively obvious things. But at the end of the day, you have bias, you have a committee full of prosecutors, no minority staff, no minority report, no witnesses or evidence that were introduced by anyone who disagreed with the obvious facts that the members, and you have members that were highly involved. And you had political grandstanding. Much of the video was edited. And Mr. Hafey admitted that. Much of it was produced for TV production. The timing was suspect. And this report in general was highly controversial, very controversial. I'll submit, I never read it before. I was shocked at just how bad it was, how shallow it was. I mean, there's lots of conclusory statements there. Not a lot of evidence backing them up. And let's look at a few other things. There are factual findings. The evidence in this hearing showed factual findings are suspect based on the evidence in this hearing, based on evidence in this court. So stuff that didn't make it in. Mr. Kash Patel, he testified that President Trump authorized, not ordered, but authorized 10 to 20,000 National Guard troops. And not only, and he didn't say, oh, that's just something I overheard, once. He talked to the Secretary of the Army with it. He followed up. He made sure that there were conversations with the mayor. That was his job, and he testified about that process at length. Ms. Pearson, she also testified that President Trump talked to about wanted 10 to 20,000 National Guard troops to prevent violence. And she said that President Trump specifically struck names as far as the speakers. This is all stuff that didn't make it into the report at all, and that she had security concerns, and much of her interview, and Mr. Patel talked about this as well, never made it into the January 6th report. I think on the National Guard issue, what's really interesting is and also Representative Buck testified that Congressman Jordan had a much different story that he had presented about whether his willingness to testify than what showed up in the report. And this wasn't something that Congressman Buck sort of remembered offhand in the midst of time. He specifically asked Representative Jordan because, Representative Buck was concerned about the election issue. He disagrees with President Trump on that, showing again his credibility. And it was just the last week or so before his testimony because he was talking to Representative Jordan about the controversy and whether or not Buck could vote for Jordan for Speaker of the House. That was a pretty important conversation and fresh in his mind. And he specifically drilled in to whether or not that happened in the January 6th report, and there was that conflict there. None of that stuff made it into the January 6th report. Then you have a couple others. For example, that was actually refuted, some of the conclusions that were refuted by evidence at the hearing. So, for example, one of the proposed findings of facts from the petitioners is that Trump also regularly endorsed incendiary figures connected with far-right extremists like Alex Jones, Alexander, Steve Bannon, Roger Stone. That's what the finding says. Well, Professor Simi admitted, recognized, endorsed the fact that President Trump had fired Mr. Bannon. And Ms. Pearson testified that President Trump, when he was striking names off of the list of people to speak, didn't even know who Ali Alexander was, and that President Trump specifically struck Roger Stone off the speaker list as well as Mr. Giuliani. So the findings of fact are used to sort of create this close collaboration when the actual evidence in this hearing refuted that finding very directly. Then we have a finding where the committee says that Trump knew his claims of election fraud were false. You've heard that argument. Well, the petitioner's witness, Mr. Swalwell, testified that, and I quote him, he said, "It was well known among myself and my colleagues and the public that President Trump believed that that Vice President Pence had the ability to essentially reject the electoral ballots that were sent from the states." That's what Mr. Representative Swalwell said. And then another thing, about the commission says about 25,000 additional attendees purposely remained outside the Secret Service perimeter at the ellipse. This is on January 6th, and avoided the magnetometers, and that Trump knew that they were armed. There's no evidence of that. And in fact, the evidence that you did hear was, and I admit it's one person, because that's all I had time to find. But it was one person, Mr. Bjorklund, who said, "I don't like being in the middle of crowds. I didn't want to go through the magnetometers, and I stayed back." That's what he specifically said. And that's also suspect. I mean, you have Amy Kramer saying, she couldn't tell whether people were armed or not. She had no idea. And yet somehow they're inferring that President Trump was all-knowing and all-seeing and knew all of this, apparently, which no one else did. Talking about the videos very quickly. They are curated and highly edited videos. Curated means, in the scientific speech, they suffer from selection bias. Cherry-picked. You pick and choose what supports your case. And they had a TV producer behind it. And that, in fact, this court saw there's a recent lawsuit, and I'm not saying that lawsuit's absolutely correct, but the person who sought to intervene said, look, I'm suing the petitioner's attorneys. Good luck with that, folks. I'm suing them because they produced this edited document that had me, that they said I made this speech earlier, and it took it out of context, and yada, yada, yada. They said all that. So at least we have some evidence about the curation process. It's evidence, of course, we weren't able to explore fully because of the compressed timelines. But that should at least give the court pause that maybe not all of this stuff should be taken at face value. And in fact, we're taking things at face value. I'll use the example of Professor Simi. So Professor Simi had that photo of Charlottesville, and he said, well, that shows right-wing violence. And I questioned him about it. And I said, well, now it looks as though there's two people who have, one sort of got this garb, and the other's got a gas mask. Can you tell me which one's the far right-wing extremist? And he couldn't. He couldn't. I asked him if he could tell who was attacking whom, and he couldn't. As was one stabbing the other, or is one grabbing that flagpole from the other, or is one hit the other and in the process of doing it, and he didn't know. He didn't know who was committing violence. He didn't know who was on which side. And I think that's an example of curated videos, curated photos, absent personal testimony saying, yeah, that was me, or that's something I took. So when Hodges says that's a video that I took, that deserves credibility. I'll give him that. But when you have a video that just says, this is what it is, and this is what happened, and this represents what was going on that day, without the opportunity to cross-examine, without the ability to identify the context of it, without the time to look at other explanations, that is suspect. And this court should not place much weight on that. At the end of the day, we have tests for congressional reports for a reason. Sometimes congressional reports pass those tests, and they should be admitted by the court, and sometimes they fail those tests. I submit to you that if this one doesn't fail that test we've already ruled on admissibility, but if the court places great weight on this, then there's no congressional report that ever should be kept out or reduced, or with little reliance placed on it, because this is about as biased and unprecedented and controversial of a process as you can possibly have. And yet, that's what the petitioners are relying on. The second pillar of their case is basically Professor Simi's testimony. And he talked about far-right extremists. And what he did is he described the Proud Boys and the Oath Keepers and the Three Percenters. And I learned a lot. I will submit that I spent a lot of time probably talking to groups that may have included those people. I had heard of the Proud Boys once before, or a few times. I knew they were sort of hardcore, but I didn't know much. Oath Keepers, I sort of thought they were a vaguely religious group, and I'd never heard of the Three Percenters. Now, my experience is not evidence before this court. But the reason I'm saying it is because I was very keenly interested in how Professor Simi was going to link President Trump to these far right-wing groups. Because I will submit for the record, I've run for a number of public offices and held office. I didn't really know about these groups at all. And so I wanted to know how this president all of a sudden knew about everyone, maybe not all of a sudden. And so I was very keenly focused on that. And Professor Simi certainly implied, in some instances almost said, that, President Trump was sort of in cahoots with these groups. But there was no evidence. There's no evidence. There's no evidence that he intended to speak to them. There's no evidence that he knew how widespread they were. There's no evidence that he didn't even know who they were. There's no evidence to even make those inferences. And so you look through this, and sure, people can say things, but there's got to be evidence. In fact, the evidence adduced at this hearing is that President Trump did not know of them. So let's take that debate exchange where President Trump said, Proud Boys, stand back and stand by. You remember that. And in fact, the petitioners were questioning Professor Simi about it, and they showed the exchange. And I will tease them a little bit. At one point, the question was to Professor Simi, Proud Boys, and this is the question. Was he, referring to President Trump, was he asked a question about the Proud Boys, or did he pick that out of his own brain? That was the question to Professor Simi. And that was a false choice. He wasn't asked the question, and he didn't pick it out of his own brain. And to his credit, Professor Simi didn't take the bait on that. He said, well, there was some crosstalk, and then he used the word Proud Boys. Well, what was that crosstalk? The moderator said, will you tell these white supremacists and these people to stand down? So it was the moderator who used that formulation, stand down. Now, I know President Trump used stand back, but pretty similar to the stand formulation. And President Trump says, well, it's Antifa's fault, and there's all this back and forth, and it's Joe Biden who suggests Proud Boys are the people. That's why we included the transcript, and you're welcome to listen to the video. It's Joe Biden who uses the word Proud Boys. And so President Trump says, well, Wallace says stand down, so I say stand by. And then former President Joe Biden says Proud Boys, so he does what the two of them ask him to do. That's how he came up with Proud Boys. And the next day, and we include the transcript of that press conference at Marine One, the helicopter there, he says, look, these white supremacists, I condemn them completely. I don't even know who the Proud Boys are, but there has to be peace and along those lines. So he specifically disavows knowledge of Proud Boys at that time. Now, the other thing that Professor Simi relies upon, he says, yeah, look, I observed, well, let me back up. Professor Simi is very clear. He says, my report did not address President Trump's intent. I'm not in President Trump's head. He said that a couple times. What he did say is, he says, well, what President Trump did was characteristic of sort of the speech patterns and methods of speaking that are part of far right-wing extreme conversations and speech. And we talked at length about, the use of the 1776, and I asked him these hypotheticals, which, frankly, are a little personal, because I've used that phrase, and I don't know, it's not Proud Boys or Three Percenters or whoever the heck they were. And so Professor Simi talked about how these sort of methods of speech. And on cross-exam, he admitted very readily, he's not hiding anything, he said, look, these characteristics, whether it's front stage, backstage, or doublespeak, he says, we all do it. And in fact, politically, people do it regularly all the time. And conspiracy theorists, he agreed with me, sort of the Hofstadter, the paranoid style of American politics. There have been conspiracy theorists and floating around political discourse for a very long time in U.S. politics. And he said, so all these methods, all these patterns are common to political discourse. So if you're looking at a politician who uses common political discourse, and that common political discourse is similar to what far right-wing extremists use for their political discourse, it's not a difficult logical leap, but it's also a false one. There's no causality. President Trump's not using these types of speeches that seem to identify these methods to communicate with Proud Boys or whoever. He's using them because everyone else does, and that's how people talk. And that's why we included the video where we have lots of folks, President Biden, Senator Warren, representatives, all using the word fight like hell, take it to the streets, all of that stuff. So that's one example of, frankly, what could be many. Now, Professor Simi from that says, well, President Trump and far-right extremists had a relationship. And I have to cross-examine him on the Dumb and Dumber movie. It didn't work out too well, but you still get to hear that on closing argument now. And so there's a scene in this movie played by Jim Carrey, sort of one of the protagonists, and he has a crush on a woman. And he travels to meet her, and he says to her, and I'm quoting, so pardon the language, he says, what do you think the chances are of a girl like you and a guy like me? I traveled a long way, at least you can level with me. He says that to her. He says, what are my chances? She looks at him and she says, not good. And then he says, you mean not good as in 1 out of 100? And then she looks at him with sort of a mixture of pity and sorrow and perhaps disgust, and says, I'd say more like 1 out of 1,000,000. And then the character has a long pause, and he smiles, and he's very happy, and he says, so you're telling me there's a chance? That's what he says. And he just gives out this big whoop, and she's just astonished. That's sort of the scene. And so to say that President Trump had a relationship with the far right-wing extremists would be analogous to saying that this character had a relationship with this woman, or vice versa. There was no relationship except in one person's head, and that was the character played by Jim Carrey. A more sinister analogy, that's not humorous, would sort of be John Hinckley and Jodie Foster. If you remember, John Hinckley was the person who tried to assassinate President Reagan. And the reason he did that is because he had this obsession, this crush on Jodie Foster, and wanted to sort of prove himself and do something great. It would be like saying that they had a relationship. No, there was no relationship there. It was John Hinckley's obsession, and Jodie Foster had no relationship with him. So when Professor Simi says there is a relationship there, or there's involvement there with President Trump, no. That's at best unrequited love on behalf of the far right-wing extremists who may like President Trump, may be inspired by President Trump, but there's no evidence that it ever went the other way. And to call that a relationship is like calling a stalker and that victim having a relationship. It is just wrong. Now, let me talk about some of the legal standards and whatnot. Let me start with engage. So engage does not equal incite. I'm going to phrase this a little bit different. I'm going to try and be a little bit different than our briefings, because you've read all that stuff. All right, so please pay attention. I'm not just going to repeat myself, I hope. Engage and incite are two fundamentally different activities. Engage means to participate in an activity, to be involved in it. Incite means to provoke and urge on, to move others to action. They are different activities. So when you say engage includes incite, you're actually saying that engage includes a fundamentally different activity than the normal meaning of incite. The normal meaning today, and frankly, the normal meaning back then. And when I say back then, during that, I mean, there wasn't an issue about launching an insurrection when the 14th Amendment came about. The insurrection had occurred, the rebellion, the enemies, the war between the states. And so Congress, I submit, was looking at engage. And the reason why Professor Delahunty talked about the Confiscations Act of 1862 is because Congress specifically used the word incite as well as engage, and then used a much different formulation for Section 3. Oh, by the way, the experts, okay? They're testifying to law. And I'm hopeful that they were helpful for this court. And they're testifying in history, and that's what judges do. And so for them to say, well, our experts got a bigger resume than your expert, and our expert's really smart, and yours isn't, whatever. Okay? We need to look at the actual sources and the reasoning behind it. Okay? And I like Professor Maglioka. I'm teasing a little bit there. But when Maglioka testified about what incite, why incite means engage, I'm going to zero in on this a little bit. He said the Reconstruction Acts were, the language was identical to Section 3. And then he looked at Stanbury's opinion. And he said, and in that opinion, that AG opinion, Stanbury said, disloyal sentiments, opinions, or sympathies would not disqualify. But when a person has, by speech or writing, incited others to engage in rebellion, he must come under the disqualification. So that's what he said. Let's break that down and put it in context. First, he says, incite others to engage. That's a little bit different than inciting an insurrection. He's motivating others to engage in what is already an ongoing insurrection, not to start someone. Well, why would he have that strange formulation? Here's why. That shows up in paragraph 16 of the Stanbury report, of his advisory opinion. Okay? And in that advisory opinion, it's 12 Attorney General opinions, 460, I think it's page 481, and it's paragraph 16. And in paragraph 16, he is talking about two types of officials that come under the disqualification. He says, because remember when Delahunty was talking about official, people in their official capacity and individual capacity, and Maglioka was talking about that a little bit, and everyone's eyes were glazing over? This is why it's important, because in the advisory opinion, what happened is, Stanbury is talking about two types of officials. He says one type of official is an official whose duties of the office necessarily have relation to the support of the rebellion. So what's that? A naval officer or a military officer, or a state senator who voted for this, or an executive branch. I mean, someone whose job was to further the rebellion. And then he said there's a second type of official. And that type of official is someone who discharges their official duties not incident to war, but only such duties as belong to a state of peace and were necessary to the preservation of order and the administration of law. So that could be a sheriff, or a police officer, or a secretary of state. Someone who does their thing, whether there's a war or not. And in the second category is where he makes this statement. Because there's a lot of other advisory opinions that Stanbury talks about insurrection and what engages. And this is the only time he uses that formulation. And the reason he uses that formulation is because then he makes an exception to the second category. He says, if you're a secretary of state, I'm teasing, or a sheriff, all right, or constable, and you're using your office as part of your duties, you're inciting others to engage in the rebellion. In other words, what you're doing is using your official position to urge them to go forth and do things. Then you no longer fall under that category of duties that are not incident to war, but rather you're disqualified. That's the context he uses that in. And that's why this whole official and non-official and types of official is important. The next way, this second piece of evidence, the second reason that Maglioka relied upon is he said, look, there were these examples, John Young Brown, which petitioners mentioned, and Philip Thomas. And what they did is, John Young Brown, he or one of them, wrote a letter to the editor. Remember that? In fact, you used that to deny our motion to, our halftime motion. I'm teasing, obviously. But what happened there is he wrote that letter. And Maglioka's testimony shifts. He shifts. And two things are important to know. One is, the House of Representatives is what disqualified. The House of Representatives said, no, we're not going to seat you, using their authority. But the second thing is that what Maglioka said, and his shift is, they did it because he had provided aid to the Confederacy. A much different standard than incite. The Confederacy is already, the war between the states is ongoing, and this is aid. And that's why, I think it was Philip Thomas who wrote the $100 check to his son, who marched off to Shenandoah Valley or whatever. That was aid. So it's a different prong. And so now we're shifting these prongs. That's the sum total of Professor Maglioka's testimony. And compared to that, you have sort of the ordinary meanings, the difference of types of behavior, and you have the Confiscation Act of 1862, where Congress specifically used incite, but didn't use engage. There's no case law supporting Professor Maglioka's interpretation. There's not a lot of case law supporting any of this, to be honest with you. But if you look at some of these recent decisions on justiciability and sort of what's going on there, there's a skepticism of the application, and rightfully so. Look, I mean, towards the end, the petitioner said, well, the Secretary has all of this authority, and states have all these authorities based on the 14th Amendment. The 14th Amendment was passed to limit state authority, not to increase state authority. It was passed to limit, and that's the framework. Now, for incite, now we'll step back. Engage doesn't equal incite. Let us assume, for purposes of argument only, and all of these, statements I'll make to say, no, we're not bound by that. Let's assume incite is the standard. Okay? What I want to point out is there is no case law on, or very little on insurrection. Pretty much none, since it was passed. I mean, there's definitions, there's a grand jury charge over there, but I mean, are there rulings on this? No. And same with engage. This court is wading into a brave new world, but the court is not wading into a brave new world when it comes to standards for incite. Under the Brandenburg standards, there's lots of that. And we're not saying that the First Amendment, pardon my pun, trumps the 14th Amendment or vice versa. What we are saying, and this we've talked in our brief, the court's required to harmonize the two. When possible, to find a construction that harmonizes the two. And the Brandenburg standards are what harmonizes it. The Brandenburg standards say this is when incitement to violence takes place, and this is when incitement doesn't take place. That's what the Brandenburg standards talk about. And so there's a couple important things. I mean, the Brandenburg standards, the Sixth Circuit has specifically rejected. It's not how a speaker interprets the speech. All of Simi's approach doesn't find any solace, it's another way of saying it's been rejected, by case law. It's not that the Proud Boy said, oh my gosh, he's speaking to me, so you're telling me there's a chance. That's not the standard. The standard is the intent and the objective words that are used. It's a plain word meaning. Now look, I get it. You know, there could be a code that if there was evidence that President Trump sat down with the Proud Boys and said, look, I'm going to give a speech, and when I say the eagle has landed, go launch your attack. Okay, I mean, there could be a pre-arranged code. But absent that, which doesn't exist here, it's the plain objective words, the objective meaning of the speech. Let me talk a little bit about causality as well. Unengaged, it has to be causality, or insight has to be causality. Look, even the January 6th report said this, that the violence began well before President Trump finished his speech. So it's difficult to see how the January 6th speech caused this. Now, I know they've argued, well, then it increased, that's 224 tweet. I'll get to that in a second. But the speech itself, there was not causality. And all the stuff pre-6, it fails the imminence test. The objective words. And you can say, will be wild means this, that, or the other. It doesn't mean violence. The objective words do not incite. They simply don't. Let's talk a little bit about specific intent. There was no intent on President Trump's behalf whatsoever, general or specific. The most one can discern is that he pressured, and he wanted other people to pressure, Vice President Pence to send the electoral count back to states for 10 days. That's what he said. And you heard him in the January 6th speech, send it back for 10 days, I'm sure it'll change, you know, let's do the right thing. That's what he wanted to do. I want to talk about the National Guard when it comes to specific intent. Now, the National Guard's important for a couple reasons because it, frankly, I think destroys their argument that President Trump did a failure to act. But let's talk about intent. The evidence on National Guard is, frankly, overwhelming. We have two witnesses, Kash Patel with Katrina Pearson, and it's corroborated, and this is important, it's corroborated by the text from Max Miller, the petitioners introduced, in which Max Miller says, wow, boy, it says to Katrina Pearson, it's a good thing we killed that National Guard thing. Well, why would he say we killed that National Guard thing? Well, because it came up in the conversation, because President Trump wanted it. And I'm inferring that it freaked everyone out, because no one wanted President Trump to mobilize the National Guard, because he would be accused of being a dictator and all this other stuff. But he certainly authorized it. How can a president who authorizes the National Guard to be used, not on one occasion, but on two, in front of two audiences, enough to give his staff concern that he's actually going to, push it really hard, he authorizes it, and Kash Patel follows up on it, to prevent violence? How is that an intent to incite? It is the antithesis. In fact, the mayor of D.C. put out this letter saying, don't give me any more National Guard. Well, why would she do that? Well, the reason she would do that is because Secretary Army talked to her, and she's like, no, I don't want this. In fact, the Capitol Police didn't want it. I think the evidence shows that President Trump was the only political leader in D.C. that wanted substantial protections to prevent the type of violence that happened on January 6th. He's the only one who wanted to sort of flood the zone with troops to make sure that there wouldn't be any violence. Everyone else resisted. Everyone else resisted until it started. And then, of course, the National Guard was mobilized, and because they already had President Trump's authorization. In fact, the National Guard was already, according to Kash Patel, was one of the fastest mobilizations that happened within a couple hours of the mayor asking for the National Guard. I don't know if you know a lot about the National Guard. I used to serve in the reserves. And mobilizing part-time soldiers, Marines, I'll be respectful to Mr. North who served there, is just a hot mess. It doesn't happen in 2 hours unless there has been substantial time pre-positioning people, getting them ready to go to staging points, making sure you have the transportation and equipment and logistics in place so that you can mobilize part-time soldiers from a disparate area in 2 hours. That is pretty amazing. And it shows that there were actual steps taken by the military with President Trump's authorization to mobilize the National Guard. So lots of evidence that he wanted to do that. Eyewitness evidence confirmed by the tweet that the petitioners themselves brought in that shows President Trump did not have an intent for violence, but had an intent to make sure there wasn't violence. All right, I don't have a lot of time left. Insurrection. I said earlier on that they're just picking something out of the hat for a definition of insurrection. And they point to this definition. If you look at that definition, it differs fundamentally from the definition they put in their complaint. Paragraph 369, I believe it was. That was an assembly of persons, and an assembly means a group organized for a purpose, acting with the purpose to oppose the continuing authority of the United States Constitution. That's the continuing authority, not 10 days, by force. Okay? So that's a different definition than the one they proposed with Professor Maglioka. And I would urge the court to follow what the Michigan court just said recently. And the Michigan court, and we filed a supplementary authority just the other day, Michigan court said a lot of great things. Rejected a lot of the petitioner's arguments, rejected the secretary's arguments. But one of the things that the court said was, look, we really don't know what insurrection is. There's lots of definitions. In fact, there's as many definitions, I'm trying to find it and I can't, but there are many definitions as people who want to think deep thoughts about it. Professor Maglioka is a smart guy, and I'm not saying that his definition's crazy, but it has no authority. It's him making it up, just like anyone else would make it up. The court said the short answer is there are as many answers and gradations of answers to each of these proffered examples, one of which was insurrection, as there are people called upon to decide them. The violence at the Capitol. No, it wasn't armed. The mob wasn't armed. We had Mr. Hodges, Officer Hodges, talking about how the gun unit was looking for firearms. There were no firearms. No one found them. There's no evidence that Trump knew they were armed. There's no evidence beyond so there were some, I admit, there were brass knuckles and some pepper spray. But deadly arms, people coming armed to actually cause an insurrection, that's not a bunch of flagpoles. The way it was used, the way President Lincoln used it when he defined it as an armed insurrection, is weapons of war to create force, not makeshift weapons. And I understand violence is inexcusable. It's really hard to say, well, there's such violence, but there's not a lot. But that's what the job of the court is to do. To say, look, this may constitute a riot, but it does not constitute an insurrection. And that's why we said insurrection needs to be grounded in the context and the understanding at the day when it was drafted and when it was ratified. And that is in the context of a civil war. You can't ignore the fact that 620,000 people were killed, that there was a massive armed conflict, and say, well, what they really meant by insurrection was intimidation to prevent a law. No, they were looking at the Civil War, and it was a response to that. All right, real quick, Hillary Rudy. As the Colorado Republican Party correctly noted, the Secretary has never enforced anything like this. The Secretary has no administrative procedures in place to make these determinations. It is, in fact, a ministerial. Look, referring to the form, the major party candidate statement of intent for presidential primary, remember those 3 boxes? The title on the form says qualifications for office, and in parentheses, you must check each box to affirm that you meet all qualifications of the office, close paren. Okay? I was surprised. I have a basis for being surprised. But apparently that's just advisory. That's just guidance. And when the Secretary says all qualifications and refers to these 3 boxes, it means something different than when the person signs it and says, I meet all qualifications as prescribed by law. So apparently when a person signs that form, they mean all the federal constitution, and that apparently gives the Secretary authority and apparently imports all of the constitutional requirements of the Colorado Election Code. But when the Secretary says all qualifications, it's really just advisory for those 3 boxes. They really could be more. That does not bear credibility. And that's because the 14th Amendment is a disqualification. It's not a qualification. I don't have time to quote from the Michigan case. You're certainly capable of reading it. I'd urge you to take a look at that, because that is good persuasive authority on what's going on and how people are looking at this. I would also urge you to take a look at the Minnesota court, which rejected the Secretary's authority. And I'd urge you to take a look at the New Hampshire decision, which basically said this is a political question. On the justiciability issue, self-executing. Look, there's some disagreement before. There's one exchange in the U.S. Senate about whether or not it was self-executing. But when Supreme Court Chief Justice Chase in the Griffin's case says it is non-self-executing, and Congress immediately responds, there is no further debate in the historical record. Justice Chase's view is dispositive, and it is viewed as dispositive. Very quickly, we've not argued this at length. I think we referred to it slightly. The Amnesty Act of 1812, I want to at least preserve that argument. The fact of the matter is Congress did, in fact, provide amnesty going forward, and that law has not been overruled. Let me end with 2 last points. I submit to this court that the initial framework that the court's used has sort of led it astray on some of these jurisdictional arguments. And the court early on said that it was preparing this case for Supreme Court review. And I think that's laudable. But I think it created a bias to reaching a factual hearing, because you don't want to dismiss something on a jurisdictional and then comes back and has to go back for a factual hearing, bounces back and forth to get everything at once. And then also, I think the court's exchange with Professor with Professor Delahunty, when you were concerned that Professor Delahunty's interpretation would render the 14th Amendment, Section 3, a dead letter. And you talked about that a couple times. It's not a dead letter if this court doesn't make a decision. It's not appropriate for this court to exercise jurisdiction. And stepping back, look, this was a 5-day hearing, 17 and a half hours, importing this whole January 6th stuff. This is a big issue, and that's a small hearing. As much as I worked at it and the petitioners and yourself did, it does not create a good, thorough, factual record, adversarial process, nor does it flesh out what these standards are to be able to apply to that. So I think there's some real concerns there. At the end of the day, and remember I talked about the rule of democracy. I want to turn back to Attorney General Sandberg. And in his advisory opinions, Advisory 12, Volume 12, 141, page 160, in 1867, the same language, he said, where, from the generality of terms of description, or for any other reason, a reasonable doubt arises, that doubt is to be resolved against the operation of the law, against the operation of disqualification. That's what he said. 2 important things. His belief was that it has to be the standard is beyond a reasonable doubt. So if there's a reasonable doubt, you have to resolve it in favor of holding an election, the democracy canon. And the second point was any ambiguity get resolved that way, because that's frankly what we are as a country. We vote on these issues. Just because, I guess to put it more crudely, when you have a hammer, when the court system is that hammer, not every problem is a nail. The fact of the matter is that the people get to decide on this. I submit that the petitioner's evidence relies on the January 6th report. It relies on inferences drawn from the January 6th report. It relies on the conclusions and the characterizations from the January 6th report, none of which meet the objective standards of certainly the Brandenburg line of cases as far as what incitement actually means. None of that meets it unless you buy into the January 6th report's conclusions. And that ain't evidence. It shouldn't be evidence before this court. I think I've come up with my full hour here. Thank God I was able to actually fill it, and hopefully intelligently. I want to thank the court for its time. I want to thank the court staff for its time as well. I know it's been a lot of work. Obviously, as petitioners began, we will end. We're not happy to be here. and we don't think we should be. We'd ask the court to review and reconsider its jurisdictional arguments, but certainly recognize that the easiest way, the most straightforward way, is looking at the well-developed Brandenburg standards and saying that President Trump came nowhere near towards engaging in violence, insurrection, or anything approaching lawless activity. Thank you very much, Your Honor.
So maybe a little bit of guidance. I have no intention of revisiting my prior decisions. Mr. Gessler may be right and I may be wrong, but that's not what I plan on doing. I plan on issuing a decision on what was in the hearing. And so I only say that so that you don't spend time addressing some of these things that I've already decided.
And Your Honor, I don't intend to. I guess one question is, with regard to the J6 report and admissibility of that, is that one that's off the table, or should I address it?
I consider that to be conditionally admitted. When I say conditionally, that meant it always meant that I may reverse myself on after the hearing.
So I'll keep that brief, and I'll keep these remarks, I think, brief. There's been consistent complaints about the January 6th report and the methodology that went into coming up with the findings. The problem is they haven't come in here and really challenged the veracity of actually many of those findings. They just complain about the process. President Trump could have come in here and testified. There are other people who could have come in here and testified, but they don't really question, again, any of the findings that we're relying on. Now, they tried to do it for a couple, I think, during the closing here, but we're not the ones who made up that President Trump knew Ali Alexander and Alex Jones. This is from Katrina Pearson. I want to talk with you about, you mentioned a couple of times Ali Alexander and Alex Jones. Do you refer to them as the crazies? Yep. Okay, and you know that, or you said that Trump likes the crazies, right? Yes. And I also define crazies as being those who viciously defend him in public. And Professor Simi testified that President Trump went on Alex Jones's show right after announcing his candidacy for president in 2015. We're not making this stuff up. So that finding is not impugned at all. And then as far as 10 to 20,000 troops, that testimony was not credible. There was no documentation they could point to support the idea that 10 to 20,000 troops had been authorized. And you heard Professor Banks say, yeah, that's a pretty big authorization of troops. You think you might see some documentation. And when confronted about it, Mr. Patel said, you know, it's kind of hiding back at the Department of Defense. I didn't have it with me. I couldn't bring it to the January 6th committee. It wasn't hiding back at the Department of Defense. The January 6th committee asked for documents from the Department of Defense. Mr. Hafey testified that the Department of Defense complied, that the request would have covered any such document. There were no such documents. Mr. Patel's testimony was not credible. Now, as far as the criticisms of Professor Simi, yeah, he's not inside President Trump's mind. He admitted that. But when pressed repeatedly by my esteemed colleague here, I was taught never to say opposing counsel's name on the record. I don't know if that's right or wrong. But my esteemed colleague pressed him. And he said, yeah, I'm not in his mind, but I have looked at these patterns of communication for my entire career, and these patterns of communication back and forth between President Trump and these right-wing extremists fits that to a T. And it wasn't just on January 6th, it was 5 years leading up to January 6th. And he wouldn't have been allowed to testify on what Trump's intent was or meaning. That's for this court to decide, but it's certainly more than a reasonable inference, given the information and the patterns that Professor Simi identified, for this court to infer that Trump knew exactly what he meant. He knew who he was talking to, and he knew what the result of what he said that day was going to be. And as far as Michigan goes, Your Honor has made your decision on this already. I addressed it without calling it the political question doctrine at the end of my earlier remarks. I think Michigan just got it wrong. There are not committed textual reasons to think this was left to Congress. It's exactly the opposite. As I said before, it cannot make any sense to say that Congress by a simple majority has to approve the disqualification, but it takes a 2/3 supermajority to disable it. It just does not make sense. And finally, they just keep wanting to ignore the 224 tweet and what Trump did after the speech. Wasn't in the findings of fact and conclusions of law, and despite the promise, they never came back to it in closing. There is no innocent explanation for that tweet, given what President Trump knew was going on. So petitioners have proven their case on the facts and the law. And as I close, I want to address two rhetorical points that Trump continues to make. First, Trump argues that petitioners' claims must be wrong because they're unprecedented. They point out that no court in the history of the U.S. has disqualified a presidential candidate under Section 3 of the 14th Amendment. They point out that no court in Colorado has disqualified any candidate under Section 3 of the 14th Amendment. There's a reason for that. Never before in the history of the United States has somebody who engaged in insurrection against the Constitution run for president after having taken an oath to protect that document. Never before in the history of the United States has a sitting president sicked a mob on the Capitol while they were counting electoral votes. Section 3 of the 14th Amendment was put in place precisely for this reason. That no president before Trump has tested it tells you all we need to know about Trump. Second, Trump asserts that applying Section 3 is somehow anti-democratic, that it will deprive people the ability to vote for the candidate of their choice, a candidate who they say is leading in the polls. Now, qualifications by definition prevent people from voting for who they want. There are probably 30-year-olds out there, probably foreign citizens, maybe an Arnold Schwarzenegger, maybe a Barack Obama or a George W. Bush who's already been president 2 times, but it doesn't matter. And the argument that Section 3 should not apply because Trump is popular could not be more dangerous. Our founders have made clear time and again that a candidate's popularity does not supersede the Constitution. The rule of law must apply whether a candidate has no chance of winning election or is a potential frontrunner. The application of Section 3 is at its most urgent when a person who has desecrated their oath to support the Constitution seeks the highest office in the land. That is when the protection is needed the most. And enforcing the Constitution does not defy the will of the people. The Constitution itself embodies the will of the people. It is the supreme law of the land and must be enforced even against popular political candidates. Here's a newsflash. President Trump lost the 2020 election. Rather than peacefully hand over power to his successor, as every single outgoing president in the history of our country has done, President Trump chose to do everything he could, say anything he could, to hold on to that power unlawfully. President Trump violated his oath to preserve, protect, and defend the Constitution. President Trump engaged in insurrection against the Constitution. The Constitution is clear. He cannot be president again.
I want to again thank everybody for their high-quality presentations and for their professionalism. And I am now officially ending the Section 1113 proceeding. Everybody have a great day.
Thank you, Ron. Thank you.